everyone. Hope you all are having a great day. This is Advocate Nikhita Kohli, Senior Legal Associate at NRI Legal Services. Today, in this video, I will be explaining the relevancy of transfer deed, and the entire concept being discussed here is also applicable to NRIs when they transfer their properties. What is a transfer deed? As the name suggests, it consists of two words, transfer and deed. Now, let us try to understand these words in elementary language. Elucidating, transfer formally and literally means the conveyance, assignment or relocation of title and property. In case of movable property, transfer is completed when title and property is physically transferred. But in case of immovable property, only transfer of ownership is required, which ultimately signifies the transfer of property. However, it is more important to know what law says about transfer. Does even any law in India talks about transfer? Answer to that question is yes. The Transfer of Property Act 1882 defines the term transfer of property under section 5. In this section, living person includes a company or association or body of individuals, whether incorporated or not. But nothing herein contained shall affect any law for the time being in force relating to transfer of property to or by companies, associations or bodies of individuals. Now, what do you understand by a deed? Deed is a legal written document that is signed and delivered by one person to another in regards to the transfer of property and legal rights. Considering the legal definition and meaning of the term deed, no Indian law specifically defines the deed. Deed is written in a manner by which it transfers, affirms or confirms the transfer of legal right, interest, obligation, title, ownership of property, etc. After understanding the meaning of the two terms, transfer and deed, we can culminate that transfer deed is a legal written document used in transfer from the legal owner to another person, which specifies the contract between the parties as to the transfer. Now, getting to a quick overview about transfer deed through a legal definition by Gerald N. Hill, who states, deed is the written document which transfers title or an interest in real property to another person. The deed must describe the real property, name of party transferring the property, the party receiving the property, and be signed by the grantor, who must then acknowledge before a notary public that the execution of the deed. To complete the transfer, the deed must be recorded in the office of the recorder of deeds. Now, moving on to the essentials of transfer deed. A transfer deed is not legal, valid or enforceable unless all its necessary requirements are fulfilled. Following pointers should be noted while making a transfer deed. First, the transfer deed must be between two living persons. An interesting fact is that only the person who is alive and existing can be involved in the transaction of transfer. Both the transferor and transferee must be living on the date of transfer to make the transaction inter vivos. Nonetheless, that person can be either natural or artificial, but existing at the time of transfer, as the section 5 of the Transfer of Property Act 1882 states. Living person includes company or association or body of individuals, whether incorporated or not. As far as the transfer to an unborn child is concerned, under section 13 and 14 of Transfer of Property Act 1882, that prohibits direct transfer to an unborn child, may be preceded by the prior interest of any other person until the birth of the child. Second essential is the property must be transferable. The property to be transferred under the transfer deed must be transferable as per the Section 6 of the Transfer of Property Act 1882. Section 6 states that property of any kind may be transferred other than the one exempted by the section itself, or any other section of this act, or any other law for the time being in force. Few of the non-transferable properties are mere right to sue, public office, right to future maintenance, etc. Third is competency of transferor. Section 7 of the Transfer of Property Act 1882 deals with the competency of transferor, and as per the said section, the below mentioned conditions must be fulfilled for transferor to be competent to transfer. Number 1, person competent to contract. Number 2, entitled to transferable property or authorized to dispose of transferable property not his own. Next, mode of transfer. Let us see that can we transfer a property in any mode to make such transfer valid? According to Section 9 of the Transfer of Property Act 1882, the answer is no. Only the modes of transfer specified in Section 9 of the aforementioned Act shall be valid. Section 9 says that transfer may be in writing or not in writing. However, transfer can be made without writing only in case where it is not expressly required by law. Therefore, when a transfer is in the form of writing, the said is reduced to transfer deed. Ultimately, transfer deed being a document must be reduced to writing only. Next essential is a new interest should be created. It means that there should be a creation of new interest, else it is not a valid transfer under the Transfer of Property Act 1882. Fulfillment of essentials of a contract. Till now, we have been able to notice that transfer deed is a contract. Therefore, it has to pass through the test of valid contract in compliance with the provisions of the Indian Contract Act 1872. The conditions or essentials of a valid contract may be summed up as follows. Number 1, offer and acceptance of offer. Number 2, free consent. Number 3, lawful consideration. Number 4, lawful object. Then intention and proof of transfer of title. It needs to be noted that a deed must be prepared in such a way that it clearly indicates the true intention of parties to involve in the transfer without any vague and misrepresentation. Moreover, it must act as a proof of transfer of title. Moving on to the contents of transfer deed. First is the transfer deed must contain the following information, which is the actual demarcation and other details of the property. Second, all the rights annexed to the property and its use. Third, the full chain of titles, that is all legal rights up to the present seller. Fourth, name, address and other required details of the transferor and transferee. Fifth, the method of delivery of the property to the buyer. Sixth, nature of transfer. Seventh, a memo of the consideration stating how it has been received. Eighth, any further applicable terms and conditions for the full transfer of ownership rights. Next, power of attorney if any has been used. Next, memo about the property ownership. Next is signatures of transferor and transferee. Now, moving on to the types of transfer deed. Number 1 is sale deed. Whenever the rights, title and interests of a property is transferred from a seller to a buyer, then it is compulsory to be documented in the form of a sale deed. Sale deed discloses details of buyer, seller, property and fact of legal transfer of interest. Second type of deed is gift deed. If a person transfers his property to any person without any consideration, willfully, a gift deed is prepared, signifying the happening and particulars of gift. Next is relinquishment deed. A relinquishment deed would be created and registered for enabling the co-owners to legally transfer their property's share to another co-owner of the property. Via this deed, the co-owner of a joint Hindu property can give up their right in the immovable asset by relinquishing their share of ownership. It is mandatory to register such a deed in the office of concerned sub-registrar. Now, you all should be wondering, that is it enough to just draft the transfer deed in a document, or else it is required to be registered? Therefore, here I would like to clarify to all of you that yes, registration of transfer deed is compulsory. The transfer deed is executed on non-judicial stamp paper, and for registration we need to present the transfer deed to the nearest registrar's office. The registration process will be completed only on the payment of registration charges and a stamp duty. These charges vary from state to state. Now, what about the enforceability of the transfer deed? Now, any type of transfer deed shall be valid only if the conditions under Section 10 of the Indian Contract Act 1872 are fulfilled. Section 10 of the said Act specifies some conditions which need to be satisfied in the mandate to create a valid contract. A contract is defined under Section 2H of the Contract Act 1872, defining any agreement which is enforceable by law. Now, moving on to the very important topic, that is transfer permitted through GPA. Let's just try to understand the concept of transfer of the assets through GPA. By giving someone power of attorney, one gives him the right to carry out certain specific legal and financial businesses on his behalf. It is a very common practice among NRIs to give POA to someone they trust to represent them to carry out their businesses in the country of their origin, since it is inconvenient for them to travel frequently. While a GPA grants broad powers to representative, an SPA talks about a specific act the representative can carry out on the behalf of the principal. If you grant someone a GPA, he can pay your utility bills, collect rent on your behalf, manage and settle disputes, carry out all bank related work, sell, gift and transfer the property. I would also like to mention here that selling property through the document of GPA had become very common practice across Indian cities, owing to the monetary benefits it offered, both to the buyer and the seller. This whole thing is to avoid prohibitions, conditions regarding certain transfers, to avoid payment of stamp duty and registration charges on deeds of conveyance, to avoid payment of capital gains on transfers, to invest unaccounted money, etc. Typically, a sale deed must be carried out for transferring property titles, following which the buyer has to pay the stamp duty and registration charges. The seller will also have to bear the burden of capital gains tax on the transaction. In a landmark case of the Honorable Supreme Court, Suraj Lamp and Industries Private Limited versus the state of Haryana and another, in the year 2011, a judgment was delivered and ruled that property transactions carried out by way of POA do not hold legal validity. The court further held that property can legally be transferred only through a registered sale deed. A POA is not an instrument of transfer in regard to any right, title or interest in an immovable property. The verdict came after interpreting various provisions of the law concerning property, saying it would not affect the validity of sale agreements and POAs executed in genuine transactions. It was strictly instructed that the municipal bodies should not entertain mutation requests for properties through GPA. In the end, I would like to conclude by stating that to transfer a property, several conditions need to be satisfied. The owner of the property can transfer the ownership of the property to his heirs by any form of transfer deed, as stated above. Moving on to the discussion on the essential elements, its registration and the stamp duty followed by its enforceability involved the process of transferring the property is a vital requirement. Hence, to make a transfer deed a valid document, all the legal requirements must be duly followed to ensure its legitimacy at a later date. The concept of transfer deed and its relevancy has been explained by me, and I'm pretty sure that it is going to help many of you. Still, if you have any query, you can write to us at query@nrilegalservices.com. In case you like this video, please like, share, comment and subscribe to our channel. Thank you.